But I want to really start with a real rudimentary understanding of the civil and criminal justice system. I promise I'm not going to give a law school lecture, but to understand what your rights are if you ever find yourself in this situation, you need to understand that there are two different systems. The criminal justice system is activated when somebody contacts the police. They should do an investigation. They turn over the information they find to the district attorney's office. The district attorney decides, is this a case that they want to pursue or not? In that process, the district attorney does not represent the victim or the survivor. The district attorney represents the state, all of us. And their goal is to punish people who have committed crimes, who have been convicted, as a way to deter other crime from happening. So in some cases, a victim or a survivor will find themselves in the criminal justice system. They don't often have very much control over that situation, and it can feel really uncomfortable for the victim or the survivor. There is also the civil justice system, and a lot of people don't understand how that works for the victim or the survivor. That system is only activated if the victim or the survivor chooses to call a lawyer and happens to find a lawyer who understands this area of law. And there are a few of us out there. Can I borrow this for a second, sure thing? This little brochure that's out on the table is put out by the National Center for Victims of Crime. They have a bar association, and there are about 600 lawyers across the country who do this work, and we put out this brochure. There's some for you there. This specific one is aimed at Oklahomans, so the law in there is specific to our state. We have about 3 members in Oklahoma. That's it. There just is not very many people focused on this. And I'm the only female out of those 3. Wow. So it was why I decided that there's a need out there that's not being met. And so I decided to go this route. And I want to talk about a couple of misconceptions about these cases. I heard a couple of them come up in the Kavanaugh situation. And again, I also don't want to politicize it, but I think we all had the experience of hearing the debate that was going on. And in that debate, I heard several just misunderstandings about how the civil justice system works. So I want to talk about those for a second. The first idea is that just because a victim didn't go to the police, well, that must mean nothing happened, right? And that's just not accurate. As Jackie said, there's a lot of trauma and there's a lot of really patchy memories as a result of that trauma. And often victims think, well, I can't tell the whole story, and so the police aren't going to believe me, so I don't want to go talk to them. And that's unfortunate, but that doesn't mean that you can't pursue a civil case. Just because the police were contacted doesn't mean that you don't also have the ability to pursue that civil case. The second misconception is this idea that if I go to the police, they'll investigate it. Yeah, not always. I have been really surprised by how many phone calls I've gotten, particularly from moms of teenage girls in rural areas, where they've gone to the police or the sheriff's office if they're out in county, and nothing is happening, and they're not hearing back from the investigator, and there's really just nothing going on. Sometimes that's the result of small town politics, which happens. sometimes that's the result of a really overstretched law enforcement division. You know, they don't have a lot of money, right? And sometimes, I don't know. You know, I look at it, I go, there's something here, how come you guys didn't do this? And I don't know the answer to that. But that also doesn't stop a civil case. Just because the police didn't investigate doesn't mean there's not a civil case there. The next step in the criminal process is the district attorney. And we're facing that race. If you live in Tulsa County, the district attorney's race is open for election 2 weeks from now. One of the discussions that you hear in there is how hard on crime are they being, yet when it comes to this kind of case, they often decide not to prosecute. And there's a couple different reasons for that that makes sense if you understand the system. One is that their burden of proof is really high. They have to show that the accused committed this crime beyond a reasonable doubt. In a civil case, we have a low burden. All we have to do is show that more likely true than not true, this version of events happened. So they're like this, right? So anytime you're making a decision, if you have to be really sure, more often you're going to decide not to go down that road, right? So that changes things a little bit. Sometimes the victim or the survivor doesn't want to testify in a criminal case, and so the district attorney will decide not to prosecute for that reason. And a lot of times it's political, right? They want to focus on the cases that are going to make the news because they got to get elected, right? So I, again, come back to just because the criminal case wasn't prosecuted doesn't mean that there's not a civil case. The one that I heard most during the Kavanaugh hearings was, he said, she said. And I don't know what people really mean when they say that, except I think they try to demean the testimony that's out there. The reality is that if you're just sitting around the dining table and he said and she said, well, you all can sit there and evaluate that, right? In a court of law, when somebody testifies, they're doing it under the penalty of perjury. That means that if they lie, that can be a crime by itself. And that difference turns what we say around the dining table, that's the difference between that kind of talk and courtroom talk, right? That is actually evidence. If they've taken an oath to tell the truth, they're under the penalty of perjury, and they say it from the witness stand, that is evidence. So when people say, oh, it's he said, she said, there's no evidence, I, as a lawyer, go, that's not how it works. Right? It was very frustrating. So I have taken plenty of civil cases where the evidence is the woman's testimony about what happened. It does not make me uncomfortable to take those cases if I believe the woman, right? And I do. Jackie and I have talked about this before. When I take a client on for a sex abuse or a sex assault case, it's one of my office requirements that they be in counseling during the whole time the case is going on. And I do that for a couple of reasons. One is, I'm not trained like she is to help people with trauma, okay? And so I'm going to get in there and stir around things in their mind, and I'm going to ask uncomfortable questions, and I'm going to make them go get questioned by defense lawyers, like Julia's brother, right? Isn't that right? Yes. I want them to have the resource of being able to deal with that emotional trauma that is created from dealing with the process. Okay? So one of the tools that I use is this counseling as a way to help the victim process, and what I find in that process is they remember more and more of what happened as they go along. So it may be that I sign a case up and I send them to counseling, and they may not be ready to testify for a year or two. And if we have the ability to kind of wait while that person processes what they've been through, then I want to do that so that they can then tell a coherent story. So I actually find if somebody calls me, they're interested in pursuing a case, they've not been in counseling, and they can tell me exactly what happened, I have a little skepticism about do I believe this person or not, because that's not normal, right? This patchy memory of, oh, I remember he had on a green shirt, or I remember there was country music playing. It's kind of what we saw from Dr. Ford's testimony. That's the norm, right? And so she may need to come see Jackie and get some more processing going. But that,
she's in therapy.
yeah, me too now.
She was really
Torn up.
by herself there.
Yeah. But just because somebody can't tell the full story right away doesn't mean it didn't happen. It doesn't mean they don't have a basis for filing a civil case. So those are kind of some of the misconceptions that are out there that we've heard in the news lately, and just kind of the lawyer's viewpoint on what those things are.
Wonderful.
And that stirs up a lot of questions.
Doesn't it?
Well,
Can I ask one?
Yes.
And this may be complicated as far as an answer, but with Dr. Ford, if she, and that I was off work of all things during this thing, so I was just like in a hotel watching it. You know, it was just kind of, because I never get to see the whole picture with news, you know,
Right.
the whole presentation. And anyway, I wonder if she, after that was all done and the FBI gets involved, is she still capable of going back and doing a civil suit against someone of his new capacity, like a judge?
Yeah, well, so his capacity doesn't change her legal rights.
Okay.
The only thing that would influence my answer to that question is that there are time limits for filing a civil lawsuit. There's time limits for filing criminal lawsuits too.
Mm-hmm.
And I don't know what Maryland law is, so I can't answer for her.
Okay.
But I can tell you about Oklahoma law on that. We actually made a legal change about a year, it'll be 2 years next month, and expanded the time period in which a child abuse survivor can file a lawsuit. And then now that is up until the child's 45th birthday, which is a great improvement where it was before. Quite frankly, personally, I don't think there should be a time limit because people come to realize what's happened to them. I mean, you were talking about when you were 8, right? It's still processing
Well,
that.
I never
It just
looked
takes
at it
time.
until I was much older.
Right.
You know?
So the longer that time period is, the better off it is for victims. But right now in Oklahoma, for the child victim, it's 45. For an adult victim, it is 2 years from the day of the event, unless they have a repressed memory, like they don't remember, and that's a hard case. Question?
I do have 2 questions.
Go ahead.
One is simple. Do you have bilingual Spanish-speaking people in your staff for the ability to serve in Spanish?
I don't have anybody on my staff who's bilingual. However, I used to work with Eduardo Mora. I don't know if you know him, but I would call on Eduardo if I were in that situation.
Great. And the other one is, I know when it comes to this type of abuse, one of the reasons so many women don't call the police and don't get help is because they're afraid of retribution. What are women's rights when it comes to that?
Well, what the legal system does in that situation is if they have reason to still be afraid of the perpetrator, there is a process for getting a protective order. And if you get a protective order, we'll order the perpetrator to stay, like, I 1,000 feet away from the victim at all times. That's the first step of protection, and then letting law enforcement know that you have that protective order, and that you're in danger because there's a violation of that protective order is the way the legal system answers that. Does that answer your question?
Yeah.
Okay.
Yeah. I think my deeper question would be what the reasons would be. Because, do they have to have proof? And that's where it gets so sticky and why women don't proceed. Because, well, I don't have proof that they menaced me, that,
Well, again, proof is that person's testimony under oath, and that's what happens in the protective order hearing, is that the judge listens to what that person has to say and evaluates their credibility. And most of the time, a protective order will issue in the kind of situation that you're describing.
So there is a hearing.
There is a hearing.
That's good to know.
In front of a judge, and actually don't even need a lawyer to go through that process. Here in town, DBIS has courtroom advocates that will walk a person through that process to get the protective order. Yeah, and they do a really good job. They've been doing it for at least 20 years. I've worked with them before, and they really help not just get the protective order, but then figure out what that victim needs to feel safe. Do we need any kind of intervention to get them out of the home and that kind of thing? So you tie them into services that are available here. And on that note, I want to mention, also on the table, I left a little card called the Victim Connect card. And that's kind of like 211 on a national level. The National Center for Victims of Crime runs this hotline, and you can call that number, and they have a directory of resources all over the country. I bring it up because I know I talked with several of you who are kind of in the field doing some of this work or dealing with volunteers in that area. I would have you call and make sure you're in their directory so that if an Oklahoma victim calls, they know how to connect with that service. And then if you are a victim, obviously, that's a resource available for you.
That victim's right bill is currently, will be voting for. How will that affect people or women who proceed with actions in reference to rape or harassment?
Well, so Marcy's law, that's the state question. I forget the state question number.
I think it's 794.
794, that sounds right.
I think
So Marcy's law is a effort to amend Oklahoma's state constitution to build in some protection for victims' rights. And among other things, it would require that law enforcement notify the victim of all court proceedings, so they know, there's a preliminary hearing in the criminal case. We're letting you know it's been set this day. It gives the victim the ability to have a voice in any plea bargaining situation, which they don't currently. A lot of DAs will listen to the families, but this makes sure that it's in the Constitution that they have that right. It does provide some additional kind of enhanced restitution for victims. Right now we have a victims compensation fund that's run by the district attorney's office, but it kind of gives some strength to that ability. There's some other elements to it, but it basically tries to do a little bit of leveling the playing field between the victim and the perpetrator. And so that's the goal of Marcy's law.
Will the defense be able to interview the victim? I've not studied it thoroughly, but someone said they researched it and that's how they interpreted it. So I was just curious what your take on that is.
It doesn't specify that the defense gets any additional rights, so I don't think that's the case.
Okay.
The defendant has currently, without any change in the law, any evidence that the district attorney has about a crime is turned over to defense counsel. right? So if the victim is given a statement to the district attorney, that is turned over to defense counsel. So nothing changes about that, if that answers your question.
I'm not sure. I'm not sure. I'm not familiar with the process, but,
If you all are interested in that aspect, there is a rally being held for Marcy's Law on Monday, this coming Monday, at the Woody Guthrie Center at 6 o'clock. I'm not standing up here saying vote pro or vote against. I am standing up here saying this is something they ought to read up on, because you're gonna have